Okay.
All right, the court is calling 2025 CR 003783 State versus Adam Keith. Can I have parties announced?
Ashley Jones for the state.
Bridget Garza for defense.
And are you Mr. Keith?
Yes, ma'am.
All right, do you have any objection to your attorney appearing by Zoom?
No.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Keith, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
In a Texas courtroom, the case of State versus Adam Keith is called. The prosecutor, Ashley Jones, announces for the state. Defense counsel, Bridget Gaddis, appears for the accused Mr. Keith, who confirms his identity before the judge. The court ensures Mr. Keith has reviewed all discovery with his attorney and understands the indictment when asked. The defense waives the formal reading of the indictment. What unfolds next will determine not only the charges that remain, but also the potential future of the accused. Subscribe now to stay with us through every moment of this gripping courtroom exchange.
So do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are going to proceed on count 2, paragraph B, waive the other counts in paragraph, and we will also waive the repeat offender enhancement allegation.
We have no objections, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
No.
And I'm so sorry, you said you're proceeding.
The prosecutor informs the court that the state will proceed only on count 2, paragraph B, dismissing all other allegations and the repeat offender enhancement. This decision narrows the focus to a single charge: sexual assault, a second-degree felony. The judge carefully explains the severity: a punishment range of 2 to 20 years in prison and up to a $10,000 fine. Mr. Keith listens attentively as he's reminded that a plea agreement with the state is not guaranteed to be followed by the court. Every word here is critical as the defendant's fate hangs in the balance.
On paragraph B of count 2?
Yes, Your Honor.
All right, did you understand in count 2, paragraph B, you're charged with sexual assault? That is a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in
The judge turns to Mr. Keith, explaining his constitutional rights: the right to a jury trial, the right to confront and cross-examine witnesses, and the right to remain silent. By entering a plea, he would be giving up these protections. Calmly, Mr. Keith confirms he understands and intends to waive those rights. Defense counsel affirms that the defendant is competent, rational, and fully understands the charges. The court then asks directly, has anyone threatened or coerced you into entering this plea? Mr. Keith replies firmly, no, ma'am. With these statements, the legal foundation for his plea is set.
right to remain silent.
No.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as the factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Keith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will
Discussion shifts to the plea agreement. The state's deal: 3 years in prison, a $15 fine, and significant conditions, including lifetime sex offender registration under Chapter 62, and a no-contact order with the complainant. An affirmative finding of family violence is attached, shaping Mr. Keith's future in profound ways. The judge carefully reaffirms the terms, asking if the defendant understands. Mr. Keith responds, yes, ma'am. The courtroom tension grows. What seems like a routine procedure is, in truth, a decision that will alter the course of a man's life forever.
find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2, paragraph B, waiving all other counts in the enhancement. Punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. There's no application. There's an affirmative finding of family violence. Chapter 62 registration, and it's a lifetime registration, and there's to be no contact with the complainant. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
The court next reviews the waiver of appeal. Mr. Keith acknowledges he signed it, fully aware he is giving up nearly all rights to challenge this case on appeal. Only pretrial motions if filed, argued, and ruled upon could be appealed. Defense counsel confirms no such motions exist. With this, the judge turns to the pivotal question: how do you plead? Mr. Keith responds no contest. The room is silent. The decision now locked into record. The consequences are immense. As the judge highlights,
Did you review the waiver of
restrictions that
appeal
follow a family
paragraph with
violence
your
finding,
attorney? Did
including
you
loss of
understand it?
firearm
Did you
rights and
sign it in
custody
both
implications?
places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense in count 2, paragraph B, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right. And just one other thing. Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodian?
6 evidence is introduced. The state offers Exhibit 1, a file of reports and attachments supporting the plea. The defense raises no objections, and the court accepts it into evidence. Importantly, there will be no live testimony, only written reports and statements. Mr. Keith acknowledges this understanding and agrees to stipulate. The court finds there is sufficient evidence to support guilt. With deliberate words, the judge declares Mr. Keith guilty of sexual assault under count 2. Paragraph B, the formality of the moment cannot mask the gravity. This judgment will shape not only years, but an entire lifetime ahead.
Custodial parent?
Yes, ma'am.
And did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Knowing that, do you still wish to continue with the plea?
Yes, ma'am.
All right, State, do you have any evidence to support the defendant's plea?
State would offer State's Exhibit 1 and all attachments.
Any objections?
We have no objections, Your Honor.
All right, and State, have you spoken with the complainant?
We have, Your Honor, in the past, and we've attempted contact recently.
All right, thank you, State. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your...
Sentencing arrives. Defense counsel asks the judge to honor the agreement, 3 years in state prison, credit for time already served, and conditions outlined earlier. The court agrees, pronouncing the sentence of $15 fine, 3 years of incarceration, and the statutory requirements of Chapter 60 to lifetime registration and no contact with the complainant. The judge also certifies that Mr. Keith has no right to appeal. A reminder follows: family violence findings bring lifelong consequences, including the permanent loss of firearm possession. With the words spoken, judgment is sealed, and Mr. Keith's path forward is set.
And also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You can't be drinking alcohol because obviously you're one of those persons who cannot drink, right?
Yes, ma'am.
If you would like, I can recommend the therapeutic community for you at the prison. They may not place you in it due to the nature of your offense, but it's to help you with sobriety and other issues you may have. I can't order them to place you in the program, but I can let the judgment reflect that I think it would be best if you were in the program. Doesn't increase the length of time that you're in custody. Do you understand?
For concluding, the judge offers a final reflection addressing Mr. Keith. She cautions against alcohol use, noting his inability to drink responsibly. She recommends placement in a therapeutic community within prison. Though not guaranteed, it could provide rehabilitation. Importantly, this recommendation does not extend his sentence, but offers a potential path for change. With that, the proceedings end. Counsel is excused, and Mr. Keith is led away. This moment closes not just a courtroom hearing, but a defining chapter in one man's life. Like this video, subscribe, and stay tuned for more real courtroom stories.